My name is Michael Curcio, and our company is called Benefits Inc. We service several clients across the country, everything from two-person mom and pops up to our largest employer has about 2,500 employees. So if you fall somewhere between that category, chances are we may have dealt with an issue that you're having. But what we're talking about today is the Affordable Care Act. I'll give you a brief history of the law, then we'll move into employer responsibilities. This law breaks employers up into two groups, basically, small groups and large groups. So we'll talk about the differences between the two there. We'll briefly touch on the exchanges, or the marketplaces as they're calling them now, and then probably what most of you really want to hear about, our last point will be strategies. In other words, what do I do with this information? So before I get into employer responsibility, I'm going to talk just briefly about the history. Of course, this law was enacted in 2010. Most of the rollout started in 2013 with FSA contributions being capped at $2,500, for example. There's also an additional Medicare tax tacked on to high-income earners to help pay for some of this stuff. You are now been required as of October 1, 2013 to send out a notification to let your employees know that the exchanges or the marketplaces do exist and that they can go there if they so choose. And open enrollment, in theory, started for those October 1, although, as we've all heard, they've had a lot of issues getting folks enrolled, but technically they did open October 1, 2013. And then also in 2013, you'd have to determine if you were a large or a small employer. In 2014, coming up, sort of the big reveal comes out January 1. This is when no pre-existing conditions anymore for adults, guaranteed availability and renewal of health coverage. You've got a 90-day maximum waiting period starting in 2014. You used to be able to wait longer than that if you wanted to before you brought employees onto your plan. And probably the largest change is that there's no longer going to be medical underwriting. The only criterion for writing coverage now for rating is going to be family size, rating area, so where you are geographically speaking, your age, and whether or not you use tobacco. Also, the exchanges are going to open in 2014, as we've discussed, and then, of course, the individual mandate and the employer mandate are also being rolled out 2014. So now on to employer responsibility. What is your role in this as an employer? Well, you need to count your employees because the onus is on you to determine your size. Again, this law is going to put us in two buckets for either small employers or large employers. And just like the onus is on you to pay your taxes every year, the onus is going to be on you to count that and declare what size you are. There are going to be new fees and taxes associated with this law. Most of those you will experience as a pass-through in your insurance rate. So you won't necessarily see those line itemed out. Some of them you will, some of them you won't. You are now required to provide your employees with a standardized summary of benefits. We'll talk a little bit more about that later in the program. And then providing employees with notification of the exchange. All of these things are your responsibility as an employer, and if you do not complete these things, you could be subject to some fees or penalties under the law. This slide basically just illustrates that nobody's exempt. Defining an employer, anybody who's got W-2 employees, we're talking to you today. If you're a for-profit, nonprofit, if you're a church, even federal, state, and local governments are having to comply with the Affordable Care Act. One of the things we need to look at when we're advising our clients on which bucket they fall into is, do you share common ownership? It's very, very common, especially across our client book and I'm sure across the country, for us to have clients who maybe have an LLC or an umbrella parent corporation that may have 5 or 6 LLCs underneath those corporations, and each one of those buckets would have their own employees. Well, in the old days, before the law was enacted, under that scenario, you could have 5 different medical plans. So you'd have maybe 5 groups of 25. Nowadays, if they've kind of aligned the regulation with what you're probably used to under ERISA, which is if you're a parent corporation or your partnership owns 80% of the voting stock of any of the subsidiaries, or if you've got related companies where partners of 5 or fewer control 50% of the voting stock, or if companies have common ownership, then they are going to be considered one company. So again, just to drive this example home, I have a client in particular with 5 LLCs. They previously had 5 plans. Now they are one large employer with 500 employees, and that's brand new for them. We've just had to rewrite their benefit package to reflect the regulations of the new law. And of course, down there at the bottom right, the regulatory discretion of the IRS overarches all of this. So you look at these regulations, you think you fit into the box, but they are going to be the final say on it. Why you need to count the employees, again, we're looking at who's full-time and who's part-time, because we need to figure out whether or not you're a small or a large employer. That is going to drive everything about what affects you in this law. So we'll need to look and see who is full-time, and that will be part of your employee count. For those full-time employees, you're going to need to provide a summary of benefits coverage, an SBC. You should have seen this already beginning October 1, 2012. Whenever your renewal month came out following that date, you should have already gone through at least one round of passing out an SBC. You could do it through a payroll stuffer, you could do it through an email, but everybody's got to get this standardized form that shows what their benefits are, what the limits are, what the cost sharing is, and then it actually will run through some examples, like if you have a maternity event or if you have an injury, things like that. It will actually show some examples of how the plan will bill out on that SBC. If you're a fully insured plan, your insurance company, your insurance provider should have given you these SBCs to pass out. If you're a self-funded plan where you're funding this insurance yourself and have a third-party administrator, then the onus would be on the employer to provide that SBC. This slide talks about the employee notification of coverage options. You would have to send out by October 1, 2013, any existing employee you had. There's a standardized form that came out that tells your employees that the marketplaces or the exchanges exist, how to access them, and that they can seek coverage on them if they want to. Now, there were 2 versions of this letter that went out. The version that says, we already offer coverage and it is compliant with the law, but if you want to go to the exchange, you can. Or the other option was, if you do not offer coverage, there was a separate notification that said, we don't offer coverage, and if you need coverage, this is where you go and how you get it. So moving forward, now that we've passed that October 1, 2013 deadline, any new hire that you bring on board, they must receive that notification within 14 days of their start date. Now we'll talk about small group employers. Currently, in 2014, a small group is going to be defined as 50 or less employees. And technically, according to the law, it's up to the states to pick 50 or 100, but I don't think there's any states that are going with the 100 definition. So it's all 50 or below. If you are an employer that has 50 or fewer employees, you are not subject to the employer penalty if you do not offer a group health plan to full-time employees. In 2016, that definition of small employer is going to raise to 100 full-time equivalents. So it is a little bit of a moving target there, and as more regulation comes out, of course, we'll be interpreting that as we move forward. But right now, if you're 50 or less, you do not have to offer coverage. If you don't offer coverage, there is no penalty to you as an employer. But if you do offer coverage, small group and individual plans must now have what's called essential health benefits. There's 10 required coverage categories. And honestly, if you've had group coverage before, none of these are going to be news to anybody. It's things like ambulatory care, ER coverage, hospitalization, things of this nature. The only thing that's going to look different that was not previously automatically offered through a group health plan is pediatric dental and vision care. So of those 10, what they call minimum essential benefits, the only one that's really going to be new to most folks is that pediatric dental and vision must be included now as a minimum essential benefit. But here's where the big changes come. These 2 and 3 here, the out-of-pocket maximum and the small group deductible ceiling. The law now states that if you are an employer with 50 or fewer employees and you offer coverage, you can no longer offer a plan that has higher than a $2,000 individual deductible. Over the years, especially in the last few years, I would see across our book of business smaller employers moving their deductible higher and higher, $2,500, $5,000, even $10,000 deductibles. They might pair that with a health reimbursement arrangement to help their employees with some of those costs, but they were raising that deductible to lower their premium as much as they could, especially during the recession. Unfortunately, now starting in 2014, for those employers who've been using that as a cost-saving mechanism, you will no longer be able to do that. So if you've got a $5,000 deductible, you're going to have to scale that back to $2,000. Of course, that's going to increase your rate, but that will take the deductible down to $2,000, and the new out-of-pocket maximum for an individual is $6,350. So again, that's something that is sort of a big change for a lot of our smaller employers. And you're limited to the metallic coverage levels, bronze, silver, gold, or platinum, and we'll discuss what those metallic plans really mean here in a few minutes. If you're a large employer, you've got what's known as the employer mandate, or as we call it here, the pay or play penalty. You've no doubt heard in the news that was delayed now until 2015, but basically here's how it works. You must offer coverage to 95% of your full-time employees and their dependents, or you will receive a penalty. And we talked there briefly about how that penalty is assessed. But the long and the short of this slide is if you are over 50 employees and you do not offer the coverage, then there will be a penalty. Coverage, the way you would receive a penalty is if the coverage that you offer to your employees and their dependents does not meet the minimum affordability standard or does not offer the minimum value benefits, and one or more of your employees seeks a tax credit through the exchange. So make sure you understand that there. If your plan is not compliant, but nobody goes to the exchange to seek coverage and receives a subsidy, then you wouldn't be penalized in that situation. But you're going to be penalized for any employee who goes to the exchange and receives a subsidy. So it would be per head for the folks who go there. Again, you're going to multiply the number of full-time employees receiving the premium tax credit or cost-sharing subsidy from the exchange in order to get the amount of your penalty. So it's not, if you've got 500 employees but only 10 of them receive a subsidy, you're only going to be penalized on those 10 folks. So how do you know? The affordability standard, according to the law, says that the individual premium can't cost an employee more than 9.5% of their household income. Well, if you work for me, then I'm going to know what you make, but I have no idea what your spouse makes. So we've come out with some affordability safe harbors. You want to look at the W-2, the take-home wages of your individual employee. You want to make sure their individual-only premium does not exceed 9.5% of that number. That's the safe harbor we go there. Or you can look at rate of pay or the federal poverty line. But as long as you're going by those safe harbors, then that's going to be the best way to gauge that on the front end. Again, you're not going to know for sure what their family's bringing in as a household, but these are some safe harbors you can look at. Exchanges and marketplaces, we've been hearing a lot about this in the news. This map basically just shows the breakdown of the states of who's doing what. So the much darker color there, those are state-based marketplaces. I think when Congress was writing this law, they assumed that a lot more states were going to sign on to the state-based exchanges. As it shakes out, the dark states there are the ones that actually did so. The much lighter color are the states that opted out and asked the federal government to operate their exchange for them. And there are a few states who are doing partnership exchanges, and those are the sort of medium colored blue there. Types of exchanges, you've got individual exchange, small group with a shop exchange, and then private exchanges. So on the individual exchange, it's either going to be managed at the federal level or by the state government. And all of these exchanges are going to be a Travelocity-style shopping experience. So imagine if you're going online to buy an airline ticket or to book a hotel, their hope is that the experience feels a lot like that. So you can put in your basic information, you'll be able to see the different plans available to you. and whether or not you qualify for a subsidy. It'll tell you all that information in theory right there on healthcare.gov or at your state-based exchange. Small group shop works exactly like the individual exchange, but it's targeted to small employers. There has not been nearly as much emphasis placed on the shop exchanges as there have been on the individual exchanges. It's our understanding that they may try to emphasize the shop more in 2015 or 2016. But it would work basically the same way. If you're a small employer, you could go to the shop and look for exchange plans there and potentially receive a tax credit if you qualify, although it's pretty difficult to qualify, I will say. And then private exchanges, we're seeing this pop up a lot. As employers try to control their costs that they spend on healthcare, a lot of employers are saying, okay, under this new system, we're going to give you a defined contribution, say it's $200 a month, and then you can go onto this private exchange that we've established for you, and you can shop among 10 different plan options and use that $200 we've given you, and you can spend more than that if you like, but here's our basic defined contribution. Again, the exchanges, these are just websites. It's kind of a slide that explains what they are. As far as the metallic levels, we talked about this briefly before, but in the new world, as we're calling it, all of the plans that you'll see will be sort of cookie cutter in nature. So there's going to be bronze, which are 60% co-insurance, silver plans, which are 70% co-insurance, gold at 80%, and then platinum at 90%. And those are distinguished by their metallic levels. So if you've seen a renewal yet for if some of you have January 1 plans, you'll actually see your options laid out by these metallic levels, and you'll have the individual rates for each individual employee laid out there for you, depending on the metallic level that you pick. Again, there are some penalties associated here. The individual mandate is one that I think there was a lot of speculation they may push back along with the employer mandate. That has not happened at this point. So beginning January 1, 2014, there will be a penalty assessed for any individual who does not have coverage. In 2014, the penalty will be $95 or 1% of the household income over the filing threshold. So if you make $30,000 a year, then your annual penalty would be $300, for example. This penalty goes up in 2015 to $325 or 2% of the household income, and in 2016, $695 or 2.5% of the household income. So trying to incentivize folks to seek coverage, and if they fall into the criterion, they could receive a subsidy in order to help them pay for that coverage. So strategies, where do we go from here? By now, if you're a small employer and you could take advantage of an early renewal option with your insurance carrier, you should have received some information on that at some point this year. Basically, what the carriers were doing was they were rolling out an early renewal program where if you're a small employer that would be adversely affected by community rating or some of the other provisions that were taking place in 2014, they were allowing you to renew early and therefore pushing back the place and time where the new provisions would affect your plan. So if you previously renewed in July, for example, you could take an early renewal in December 2013, and then you wouldn't have to renew your plan again until December of 2014. So it would just kind of kick that can down the road an extra 5 or 6 months to give you some time to prepare your budget to comply with the new law. When we're looking at the renewals in 2014, you want to evaluate the new community rating and the new plan designs with each carrier. Community rating is going to affect everybody differently. Basically, if you're an under 50 group, they're going to take all of the group's rating averages or rating criterion, and they're going to factor everybody to the middle. So if the older, sicker groups, for example, had much higher rates before, younger, healthier groups had much lower rates, what they're going to attempt to do is to bring everybody to the middle. So if you've got a relatively young, healthy population, you may have previously had some pretty low rates. Community rating is going to adversely affect you, and so we want to start looking at those issues so that we can budget for them. A lot of folks, in order to control their costs, are going to defined contribution models. Again, this is just what it sounds like. Here's $300 a month. Pick from any of the plans you choose. You can spend that money however you like. You can buy up to a more expensive plan or just spend the money that we've given you. Self-funded plans. This is something that would never have been considered before if you didn't have more than, say, 300-400 employees. In the new world, self-funded plans are not subject to community rating. They're not subject to a lot of the other provisions in the Affordable Care Act. So now you've got groups as small as 50 or even 25 that are going to a self-funding arrangement to try and avoid some provisions of law that adversely affect them. So that's something we're starting to see a lot of our smaller groups wanting to take a look at. And then, of course, in the small group market, you could look at the shop exchange. Again, there are tax credits available to some small businesses. Just a quick primer on that, you basically have to have an average W-2 wage earners in your business making less than $40,000 a year to qualify for the tax credit there at the shop exchange. Large employers, this is where you really want to roll your sleeves up. You want to get your counts correct. You want to look at your part-time versus full-time employees. The definition of a full-time employee under the new law is 30 hours a week. So we're seeing a lot of our, especially chain restaurants and things that we manage, as they're going into 2014, entering the look-back period for the penalty. We're seeing a lot of our employers finding ways to try and scale back folks to part-time work. So that is something that large employers need to consider as they move forward. Also, you want to reevaluate the carriers like you never have before, because there's been a lot of fruit basket turnover in who's got the strongest rates in what states as a result of this law. For instance, where I do a lot of business in Tennessee, for years Blue Cross Blue Shield was the most competitive in the small group market. On the other side of 2014, you could see Aetna, you could see United Healthcare, other players getting much more competitive in both small and large group markets. And then again, that self-funding versus level funding. Self-funding plans, self-insured plans are not affected by the law, so that's something that a lot of our clients are starting to ask about, and we're showing them with their renewal options. So it's all part of the menu of options at this point. All right, and just a quick disclaimer, I'm not an attorney, and my attorney got called away to a meeting, so I can't even say that she is because she's not here. But if you've got deeper questions, you want to dig into it with your accountant or your legal counsel. But of course, if you need us, we'd be more than happy to advise with you as well. And there's our contact information for you. Jeremy?
Yeah.
Hopefully I got through that in a timely manner.
You did. You were able to squeeze this all in. I don't think we actually got started until about 15 after. Michael, yeah, you did a great job in condensing the information. I think you could have probably talked for a couple hours.
Yeah.
I think maybe we'll have to reconsider scheduling another one of these, and hopefully we don't have some of the same technical issues the Marketplace website has had. If there are any questions for the people who have stayed with us, please use the chat function, and we will address your questions now. And also, as Michael said, if you want to follow offline, please reach out to him. His phone number is on the screen now. You can also email me with questions, and my email is jyohe@alta.org. And we have recorded today's presentation, and after some editing, we will have it available on Alta's website at alta.org/title topics. I don't see any questions coming in right now. I had one, Michael, and
sure.
I mean, ALTA has membership that fits into both the small and large groups that you discussed, but the majority fall into the small group category. Could you maybe touch on it again? Maybe what are the one or two takeaways that people in the small group should leave this webinar knowing and understanding?
Yeah. The first thing you'll need to understand is that there's a pretty good chance that your rates are going to go up. And I know that's not exactly what you wanted to log in to hear today, but as your renewal starts coming out in 2014, it's going to look entirely different to you. And part of that is because carriers are having to absorb the risk of not underwriting people for health criterion. So you are going to see now a different rate for everybody on your plan who's a different age. So whereas before you had a composite rate, so the 25-year-olds on your plan had the same rate as the 55-year-olds on your plan, everybody now is going to have an individualized rate. It's going to be based on their age, the number of family members they're trying to cover, where you are located geographically, and whether or not you use tobacco. And on the tobacco piece of it, I do know some of the carriers have announced that they're actually going to throw that criterion out because they've determined there's really no way for them to regulate it. They're not ever really going to know if you're, burning a cigarette on Saturday when you're hanging out in the backyard or not. So really you're just looking at age, geographic location, and the size of the family. I would say that's probably the major takeaway. 90% of small employers are used to looking at composite rates. So you're going to have an individual rate for everybody, which is going to make payroll a whole lot more fun, a whole lot more interesting when it comes to deducting those premiums from those paychecks.
So work in the HR department is going to be a little more time-consuming.
Yeah, that's right, and so that's why, and not to toot our own horn, but any broker out there that's a real full-service broker. For example, we help all of our clients with their payroll and HR issues. We're providing a payroll deduction file to all of our clients. So hopefully you're working with somebody that can help you with that because this can get pretty time consuming, and that's why folks like us are in business. So if you're not working with somebody, I definitely suggest you reaching out to somebody locally, or of course you can call us if you like.
Okay, Michael, I actually have a question came in from Cheryl. She's an employer with 60 full-time employees, and she wanted to know if there's any downside to having their employees go through Obamacare and selecting the program they want as opposed to maintaining their own private exchange. And she says we would give them a contribution, but can that go right to Obamacare?
Well, no, I think if I understand the question correctly, so Cheryl, at 60 full-time employees, of course, you're considered a large employer. So if you don't offer coverage, but you want to do a defined contribution, if I understand this question correctly, then your best option there would be just enacting a private exchange, and that would be easy enough to set up for your employees. You could just offer them basically a cafeteria of plans, so literally the old-style cafeteria plans, and say, okay, you can choose from these 10 or 20 different plan designs, and we're going to give you a predefined contribution. If you send your folks to the exchange and you're not offering coverage that meets minimum essential value or minimum essential benefit, which at that point, if you were just doing a defined contribution and saying, go to the exchange, we'll give you some money, the government's not going to see that as that's not going to count as an insurance plan. So you'd want to, if you're going to go the defined contribution route, you'd want to go to a private exchange setting.
Okay. I was going to say, Cheryl, if we didn't answer your question appropriately, just please follow up with us. But she said thank you. So good job, Michael. Any other questions? Go ahead and feed them into the question box or the chat box. Don't see any others. Michael, I was going to ask you, at the end of the day, if small businesses were going to expect their healthcare premiums to go up, and you pretty bluntly said yes, unfortunately, right?
Yes, I mean, as a general rule, that is correct, and that's correct for a number of factors. That's not just me being pessimistic, Jeremy, by the way. If you're a smaller employer who had younger employees, then we know your rates are going to go up because of community rating. Statistically speaking, if you're a smaller employee who had older, maybe even a sicker population regardless of age, then you've already seen your premiums rise over the last several years. So as a reaction to that, statistically, it's very likely that you have raised your deductible beyond that $2,000 ceiling that's now enacted. So not only would your premiums be going up if you had younger, healthier people because of community rating, if you've got older population or a sicker population, then you've probably raised your deductible. So in 2014, you're going to have to lower that deductible back down, which is going to cause your premium to rise.
Okay. Well, I think unfortunately in the title industry, the average age for employees is easily probably above 40 or 50. So,
Okay.
Some questions are coming in now. People are, Michael, if you got some time, want to hang out just for a few more minutes?
Absolutely. The creative juices are flowing, so that's fine. If people have questions, I'll be happy to answer them.
All right. Well, here's probably an easier one for you. What is considered a full-time employee? Is it hours per week?
Yeah, you're looking at 30 hours per week or more, and that's a new definition. So you'll want to look at that. There's a look-back period as far as the penalty's concerned. So since the penalty's been postponed to 2016 for large employers, you're going to look back 6 months. You can choose a window basically over the last 12-month period and say, okay, this person either worked an average of 30 hours or more or 30 hours or less.
Okay, all right, and then a couple of questions from a business perspective, ownership perspective. Ralph says they are employer with less than 50 full-time employees. Can different plans be offered to the owners and the employees?
Yeah, so that's a good question. Carve-outs, I want to be clear, are we talking about offering coverage to ownership or management and not offering to others, or just offering different plans?
It just says different plans.
Okay. Yeah, you can offer plan options. You will no longer be able to prevent employees from opting into it was much easier to class out employees before, where you could say, okay, we want to segregate our hourly employees versus our salaried employees, that sort of thing. Now everybody's going to be defined as either full-time or part-time. So the short answer is no, but it would really kind of be fact-dependent, and you'd want to talk to your broker and make sure that you're working within the parameters of the law. Sorry, I can't be more specific. I just know that there's sort of a lot of mitigating circumstances there, so you definitely want to get with your broker on that.
Okay. There's a question about the notification form. Is there a general employee notification and coverage form that is available to companies?
Yes. There is we're talking about two different things here. So there is the exchange notification, which should have gone out to everybody by October 1, and then any new hire within 14 days. And there is literally a sample notification. If you live in one of the 36 states that is using the federally facilitated exchange, so you do not have a state-level exchange or a shared or a partnership exchange, but rather you are one of the 36 states that opted not to operate an exchange, then there is a standard form that is available that, and like I said, there's two options, one that says you do offer coverage or one that says you don't offer coverage. We have those available and sent them out to all of our clients. I believe it's also available on healthcare.gov, but there is a standard exchange notification. Now, just in case the caller or the question was about SBCs, that is different. So if you have a benefit plan in place, at renewal, you have to provide your employees with a summary of benefit coverage. So those are two different things, but can sound the same.
Okay. Thanks, Michael. And that the website again is healthcare.gov?
Healthcare.gov, if you have a federally facilitated exchange. If you're in a state like Washington State or Kentucky, for example, that are doing their state-level exchanges, or California, then each state will have its own individual website.
Okay. Jennifer wanted to know if these changes have any impact on health savings account plans.
Well, yes and no. In order to be compliant with the law, most HSA plans had a higher deductible than, say, $2,500. So now that the deductible ceiling is set at $2,000, if you're in an HSA plan, an HSA compliant plan that is, chances are your deductible is going to be higher than what the ceiling allows for. So in that case, your plan would no longer be compliant under the new law, and it would go away. You'd have to choose a new plan. So they don't specifically prohibit HSAs, but because of the deductible ceiling, it makes it difficult to back into one.
Okay. All right. Thanks, Michael. How about one more? We're getting kind of a lot of specific scenarios on how how this will impact each company. But Tom asks, he says they have 5 employees and wants to know if they can offer a plan with employees paying their own premiums through payroll reduction.
Well, so there would not be an employer contribution then?
Not sure. Doesn't say.
Okay. We thought if what Tom is asking about is what I think it is, it's basically through a Section 125 plan where you could have your employees go out and seek individual coverage, and you could give them a defined contribution through that Section 125 document. That has been ruled that's a no-no now under the new law. We thought that was going to be compliant. In fact, there was a company called Zane Benefits that came out a few months back, I remember, and they were saying, hey, you can do these Section 125 plans for your employees, and it'll count as credible coverage. There's actually a ruling that came out a couple of months after they launched their big business model, and they said, no, in fact, you can't do that. So if that's what Tom's asking about, it's in fact not compliant. So again, that would be where you're saying go buy individual coverage, and we will help you by payroll deducting those premiums pre-tax. That's not going to fly under the new law, unfortunately.
Okay. Well, Tom, hopefully we were able to answer your question. If not, again, Michael's phone number is on the screen. And as to a few of the others who we didn't get to your questions, again, Michael would be more than happy to help you out with this.
Jeremy,
yeah, go ahead.
I was just going to say, in addition to the phone number, we're also email-centric these days. You may rather email me, and I don't think it's on the screen, but my email address is mcurcio, M-C-U-R-C-I-O, at benefits-inc.com.
All right, great. Thank you. Again, as a reminder, today's webinar has been recorded and will be available next week on Alta's website at alta.org/title topics. Just want to apologize again for the technical issues and the delay in getting started. Michael, thanks for some of the great information on the Affordable Care Act and how it's going to be impacting Alta members.
My pleasure. Thanks for having me.
All right. Well, that will bring us to the conclusion of today's presentation. Michael, thanks for joining us, and I hope all the listeners found today's presentation useful. Take care, everyone.
Thanks a lot.